Employers, there's a new wage theft law in Minnesota that takes effect on August 1st, 2019. It's a criminal law, and I'm going to tell you about that right now. So generally speaking, if employers weren't paying employees, there was some way to charge it out criminally for prosecutors, but now the law has been amended to make it more clear. And that can be found, that new law that takes effect August 1st of 2019, at Minnesota Statute 609.52, which is generally our theft statute, specifically though in subdivisions 2, parens 13 and 19. And basically what it says is this: the crime of wage theft occurs when an employer, here's a big part, with intent to defraud, does one of these four things. And I'll read off the language for you and summarize it. The first is if an employer fails to pay an employee all wages, salary, gratuities, earnings, or commissions at the employer's rate or rates of pay, or at the rate or rates required by law, whichever is greater. So that means sometimes if you're violating the minimum wage law, for example, that's one way that this can kick in for you. The second, or if, for example, you have a standard hiring practice where you hire someone at $15 an hour for a certain position and you're not paying an employee that despite it being at that position, that arguably would fall under that part. The second part is where an employer, again with intent to defraud, directly or indirectly causes any employee to give a receipt for wages for greater the amount than it was actually paid to that employee. So this would be kind of tricky. This would mean that an employer would have an employee give them a receipt saying, hey, you just paid me $500, and really the employer paid them $300 or something like that. I don't think that's going to happen very often, but if it did, this new law will cover that. Third, where the employer, again, this is all requires with intent to defraud, which is important. I think that's a defense that's sort of built into the statute already. It's and something that I would focus on if I'm defending an employer in this situation. Third, directly or indirectly demands or receives from any employee any rebate or refund from the wages owed to the employee under the contract of employment with the employer. So that's where an employer, let's say, I've paid you $1,000 for your work the last week, and I demand that you pay me back some of that. Again, it requires the intent to defraud, though. And fourth, makes or attempts to make it appear in any manner that the wages paid to any employee were greater than the amount of actually paid to the employee. Use your imagination on that one. So there are penalties that kick in here, and they all come from the amount of the alleged wage theft. So if the wages stolen is more than $35,000, the maximum penalty is 20 years in prison. There's also fines that go along with these, but I'm not going to talk about those because people usually care more about the prison time they're facing than how much a fine is. Second, if the amount of wages stolen is more than $5,000 but less than $35,000, then we're looking at a 10-year maximum statutory prison term. If it's between $1,000 but not more than $5,000, we're talking about a max of 5 years in prison. And finally, if it's more than $500 but less than $1,000, we're talking about a 1 year maximum, which is what's called a gross misdemeanor in Minnesota. So if it's more than $1,000, you're dealing with felonies. If it's less than $1,000, you're dealing with a gross misdemeanor. Now, it's important that this wage theft can be aggregated within any 6-month period, which means they can combine. If you've done this a couple times, you can't say, well, one was for $1,000 and the other one was for $5,000. So these are really just a couple of lower level felonies. No, they can add up the $1,000 and the $5,000 as long as it all happened within a 6-month period and get you to that $6,000, which is more severe that you're facing time on that. So there's a couple things to watch for. Obviously, if you're an employer, what you want to do is consult with an employment lawyer if you have some wage issues going on at the time. But if you're not able to pay those wages to employees, then I suggest you call a criminal defense lawyer who understands this new law, because we may be able to take proactive measures to save you from being charged with these felonies Or if you're already charged, there are some, I read into this statute that there are some defenses that could apply to employers. There's two situations basically. There's on the one hand an employer who's really trying arguably to defraud employees, and that's one thing that I think this wage theft statute really gets after for people. But the other part, an employer who all of a sudden is rolling into bankruptcy or something and perhaps didn't have the intent to defraud, I think that's a built-in defense here, and I think those are two different situations that a lawyer ought to look at when representing someone who may be under investigation or charged with wage theft. I'm criminal defense attorney Ryan Pacyga. If you have any questions about this law, employers, or any other felony cases, you can always give me a call at 612-339-5844 or find me at arrestedmn, like Minnesota.com. That's arrestedmn.com.